Hello, Namaste to all. Welcome to this series of lectures on vigilance and disciplinary procedures for those who are handling it in the various central public sector undertakings, nationalized banks, Government of India, Government of the States and various autonomous bodies. This lecture is basically to give you an bird's eye view of the vigilance disciplinary procedures that we follow in the government system. And we will run you through the entire procedure in about 10 to 15 minutes, and which will help us to understand our role and functions whenever we are handling such cases in our department. The procedure for vigilance of disciplinary procedures normally begins with the complaint that are received in the department. Now, this complaint could be a complaint directly by a person, or it could be referred by the Central Vigilance Commission to the department for necessary action, or complaint could also be from various sources like audit report or CAG para. Whenever a complaint is received from a person which is not anonymous or pseudonymous, and there are verifiable facts there, the next step normally is to find out whether the complaint is prima facie true or not. So we normally set up something called an investigation team, which is preliminary investigation. Now, preliminary investigation could be by the department, could be by the CBI. If the complaint is of serious nature involving private persons having interstate ramification, international ramification, obviously the investigation, that is preliminary investigation, would be carried out by a expert body like Central Bureau of Investigation. If the investigation is carried out by the department or the CBI, in any case the purpose of the investigation is to prima facie come to the conclusion whether the complaint reveals any misconduct on the part of a suspected public servant, and if so, if the investigation reveals there is a prima facie case, then the purpose of the investigation is also to collect evidences, because without evidence there is simply no point going forward. So it is possible that the investigation reveals that there is a misconduct on the part of the government servant, but there is not sufficient proof to proceed further. Then there is no further action. Investigation, the work after the preliminary investigation, there are various possibilities. The nature of the complaint may reveal a misconduct which is minor or very small misconduct, and the discipline authority may take a view that a warning or a transfer or some other administrative action is sufficient. Only when there is a seriousness involved in the misconduct and the department feels that it must penalize the government servant if this misconduct is found to be true, in that case, if the investigation reveals that the misconduct is having some kind of a vigilance angle, we consult Central Vigilance Commission, and this is called CVC first stage advice. Now, CVC's jurisdiction do not extend to everybody in the government. So basically CVC would be advising the government in the cases of middle and senior level employees. So if you see the jurisdiction of the Central Vigilance Commission, CVC is the chairman of the committee that appoints the director of the CBI. So by virtue of this power, CVC has the control over the Central Bureau of Investigation also. The CVC exercises superintendence over the CBI in prevention of corruption cases. So the Act provides this power to the Central Vigilance Commission. Then all Group A officers of the central government are covered by the jurisdiction of the CVC. That means in any case of vigilance case of a Group A officer, consultation with the CVC will be mandatory, as you have seen. Members of the All India Service in connection with the affairs of the Union. So IAS, Indian Administrative Service, Indian Police Service, Indian Forest Service, they are all covered by the jurisdiction of the CVC. Then Chief Executive of the members of the E8 and E7. E8 for Schedule A and B PSUs and E7 for the Schedule C and D PSUs are covered. Not below this, that means officers below the rank of E7 are not covered by the jurisdiction of the CVC, and in their case consultation with CVC is not mandatory unless it's a composite case or there is a reference from the CVC. RBI, NABARD and SIDBI, it is grade D and above officers. Bank scale 5 and above, GIC manager and above, LIC senior divisional managers and above, and officers drawing pay of 8,700 in autonomous bodies, societies of local authorities. This 8,700 is of the 5th pay commission. So in the case of after obtaining the CVC's first stage advice, the discipline authority will now proceed for the major or the minor penalty procedures. At this moment, it is sufficient to mention that there are 5 major penalties and 5 minor penalties. Major penalties are dismissal, removal, reduction in rank, compulsory retirement. Minor penalties are smaller in financial effects and other effects like withholding of increment, censure, reduction by 1 stage in the same pay scale. These are minor penalties. Now, in case of a minor penalty, we issue the statement of imputation of misconduct to the government servant. This is because no action can be taken against him without at least informing him and giving him a reasonable opportunity of defending himself. So therefore, how do you give him a reasonable opportunity of defending? You inform him of the charges or whatever misconduct he has committed. And in minor penalty, we call it something called the issue of this is called statement of imputation. Whereas in the major penalty procedure also, we inform the charges to the government servant, but now we call it as charge sheet. There is fundamentally no difference between them. In both the cases, whether it is minor or major, basically we are informing the government servant and giving him a reasonable opportunity. We are informing him what are the misconduct he has done. But in the shape and the format and the content, there is some difference in the charge sheet and statement of imputation. We will talk about charge sheet later in some other module. We will devote ourselves to framing of the charges, how charge sheet is framed and other instructions on charge sheet in a later video. But at this moment, it is sufficient to understand that charge sheet has got actually 4 components. One is called article of charge. Article of charge is the substance of the misconduct that the government servant has committed. So it is written in 3, 4, 5 lines maximum. And with the articles of charge, we tell him all other details in the statement of imputation, which normally we issue in the case of minor penalty. So for each article of charge, there is a statement of imputation which is issued. The third thing in the charge sheet is the list of documents by which the charges are proposed to be proved. So the list of documents are informed to the government servant, and the government servant is informed of the 4th component, that is the list of witnesses by which the department intends to prove the charges. So there are 4 components of a charge sheet: articles of charge, statement of imputation, list of documents and list of witnesses. Now after the charge sheet is issued, normally the charge sheet is in the forwarding memorandum of the charge sheet, we write that as per rules, he is required to be given at least 10 days time to give a statement of defense. So 10 days of time is given to the government servant to reply to the charge sheet. Now 2 things are possible in the consequent to issue of the charge sheet. One is that he may admit the charges. The second is he may not admit the charges. Now, this admission of the charges would not be very common. What would be more common is that he does not admit the charges. Now, if he admits to the charges, let us dispose of this area first. So, in case he admits to the charges, and that should be unconditional, there should not be any conditions attached to it. if the charges have been admitted unconditionally, then the disciplinary authority has to now take a view that what penalty he will impose. So here, after the admission of the charges, the disciplinary authority decides on the penalty and issues the penalty order. The matter ends. Of course, what penalty he will impose will depend on the misconduct and other relevant factors. But the Government of India has clarified that once the charges are proved, and of course when he admits the charges stands proved, in that case, once the charges are proved, the disciplinary authority cannot exonerate the government servant. Some penalty should be imposed on him, even if it is the minor most penalty of censure. So, in case of admission, the story ends here. On the other hand, he does not admit to the charges. Now, this is a very important area we are coming to. He does not admit to the charges. In case he does not admit to the charges, what is normally done in the department is we appoint an inquiry officer and a presenting officer. So, the moment the charge officer denies the charges and furnishes his written statement of defense, we do not examine what he has written. We do not examine his reply, and we straight away appoint the inquiry officer and presenting officer, thinking that he has not admitted to the charges and therefore inquiry will now have to be done. Although 90% cases it will be right, but at this stage when he does not admit to the charges, it does not mean we will have to appoint an inquiry officer or a presenting officer. We must at this stage examine his reply. Now this is the most important area which is missed by many disciplinary authorities organizations. In case he does not admit to the charges, we must examine the reply, and if we are satisfied with the reply, charges could be dropped at this stage also. So this is a very important area we should not omit to do. Drop the charges if the reply is acceptable. Disciplinary authority has inherent powers to drop the charges even at this stage in case he is satisfied with the reply given by the charge officer after the charge sheet has been issued and he has not admitted to the charges. So what I mean to say is it is not necessary that he does not admit to the charges and we will immediately have to appoint an inquiry officer. Reply must be examined and then the disciplinary authority should come to the conclusion whether he should drop the charges or he should appoint the inquiry officer and the presenting officer. Now, in case the inquiry officer is appointed, that means the disciplinary authority is not satisfied with the reply furnished or the statement of defense given by the charge officer, he may appoint the inquiry officer and presenting officer, that is always simultaneously, to conduct the inquiry. So, inquiry officer, once he is appointed, he conducts the inquiry. In this small video, short video, we will not go too much into detail of what and how the inquiry is conducted, but at this stage, you need to only note that the basic job of the inquiry officer is to hear the evidence and collect the evidence of both the sides and then come to the conclusion whether the charges are proved as per the evidence produced by the presenting officer on the one hand and as per the evidence produced by the charge officer on the other hand, and come and write his report whether the charges are proved or not proved, and he has to give his report and his findings in respect of each articles of charge. It is possible that there are 4 articles of charge, he may find 2 articles as not proved and 2 articles as proved, he may find all the articles as not proved, he may find all the articles as proved, it could be anything. So we will talk about how inquiry is conducted in a separate video. This is a very, very important part and the functions and roles of the charge of inquiry officer. Now, after the inquiry is over, he submits his report to whom? He submits his report to the discipline authority who had appointed him. So, who appointed the inquiry officer? It is the discipline authority who had appointed the inquiry officer, and he will submit his report to the discipline authority. Now, this is again a very important area. Now, discipline authority is not bound by the report of the inquiry officer. He may agree with the report, he may disagree with the report, of course, for reasons to be recorded by him. But important point and something to be noted and very interesting is that discipline authority who appointed the inquiry officer is not bound by his report. So he will apply his mind independently. He will go through the report, he will see whether based on the evidences, the findings arrived at by the inquiry officer is based on evidence or not. It is possible that he may disagree with the report and the analysis of the inquiry officer and comes to the conclusion that his view is that the charge officer should be exonerated. Although it is possible that inquiry officer may have found charges as proved, discipline authority comes to the conclusion charges are not proved. It could be the other way around. Inquiry officer could have recorded that the charges are not proved, and the discipline authority, disagreeing with the inquiry officer's report, comes to the conclusion charges are proved. However, before taking his view, he will have to consult now the Central Vigilance Commission or the UPSC, as the case may be. As you have seen in the case of PSUs, banks, autonomous bodies, etc., CVC will be consulted, and in the case of government, for all Group A officers, although CVC was consulted in the first stage, but now in the second stage CVC will not be conducted. In the case of Group A officers, second stage advice of the CVC will not be necessary, and only UPSC will be consulted. It may also be noted here by all that CVC second stage is not necessary even for PSUs, banks, public sector undertakings, in case the discipline authority is taking a decision which is not in variance with the CVC's first stage advice. So this is important, and kindly note that CVC's second stage advice is not necessary if the discipline authority is not varying with the CVC's first stage advice. So need for second stage advice only and only if the discipline authority's decision is in variance with the CVC's first stage advice, not otherwise. So instructions dated 3/12/2014 and finally again on 10/7/2018. In other words, it is possible that CVC may have advised major penalty, but the discipline authority now disagrees or is of the view that a minor penalty should be imposed. So CVC will have to be consulted, because now we are varying our decision with the CVC's first stage advice. However, if the discipline authority is of the opinion that major penalty should be imposed, then there is no need to consult CVC again here. However, if they are consulted, then the discipline authority will obtain the advice of the CVC or UPSC, as the case may be, and send that advice to the charge officer to obtain his representation on it. So the discipline authority will finally take a call or final decision whether to penalize or exonerate a government servant after considering the representation of the charge officer on the CVC's UPSC advice. So UPSC CVC advice must be given to the charge officer, and his representation obtained. Only thereafter the discipline authority will decide whether he should penalize the government servant or he should exonerate the government servant. So you can see the whole story started from complaint and it ends here. If there is a higher authority than the person who has imposed the penalty, there is a, under rules, therein the rules provides for an appeal to the next higher authority, and as per the CCA rules 1965, this appeal lies within 45 days of the imposition of the penalty. There is also the provision for revision and review. This basically means the difference between appeal, revision, review in very short is that appeal is to the next higher authority, revision could be even to the higher authority than the appellate authority. However, appellate authority can also revise the orders passed by the disciplinary authority, and review is to the highest authority. In Government of India, it is to the President. So next, and the story ends here. Many people say after this he can go to the court. It is very correct, he can go to the court, but this again has to be noted, very important area, that court is not an appellate body sitting over appeal considering the disciplinary authority's decision. Court is considering the petition filed by the charge officer or an application filed before a tribunal in their role as judicial review. So judicial review is not the review of the decision of the disciplinary authority. So they don't consider whether the penalty is right or wrong or harsh or lenient. It is not the job of the courts. So the courts go into the question of in matters of disciplinary authority in their role as judicial review, and judicial review is review of the process of the decision and not the decision. So they don't see whether the decision is right or not. They only see whether the process, that means this entire process, has been correctly done or not done. In case it has not been done and it has caused prejudice to the government servant, the accused government servant, they may pass necessary directions. So kindly note, judicial review is not an appellate, they are not, the courts are not an appellate forum. They only review the process of the decision and not. We left here in the case of minor penalty, we talked of the major penalty, what is the procedure. In case of minor penalty, after the statement of imputation has been issued by the disciplinary authority, he will of course consider the reply, examine the reply of the government servant, and then come to the conclusion whether he will penalize the government servant or he will exonerate the government servant. In case the government servant is a Group A officer, UPSC will again be consulted, and thereafter we will follow the same series. That means the UPSC's advice will be given to the government servant, then the disciplinary authority will decide he will go for penalty or exoneration. It is also possible that based on the reply, the disciplinary authority decides to conduct an inquiry. It is possible in minor penalty cases, it is not the right of the government servant, but disciplinary authority on his request or suo moto, the disciplinary authority feels that an inquiry should be conducted. Maybe even in the minor penalty procedure cases, there could be witnesses involved, and that is their evidences can be only recorded in an inquiry. Therefore, even in case of a minor penalty, it is possible that disciplinary authority appoints an inquiry officer to conduct inquiry. In that case, the same cycle will be followed. So this is all about the entire procedure, and I hope this will be very useful to you dealing with cases